Good day. I am Bill Rochelle, the columnist and editor-at-large for American Bankruptcy Institute. Once again, on Rochelle's Daily Wire Video Edition, we're going to mention a case about which I have not yet published a story. That story is going to come out sometime soon, but I'm not sure exactly when. What I'm talking about is a very, very big issue concerning bankruptcy law. The question is this: to what extent, if any, are arbitration agreements respected and enforced in bankruptcy cases? In other words, if the debtor and the creditor have an arbitration agreement in their contract, is that arbitration agreement never respected, never enforced, always enforced, or maybe sometimes enforced? And if sometimes enforced, then under what circumstances? So far, we have no good guidance from the U.S. Supreme Court. What we do know from the Supreme Court is that, generally speaking, not particularly regarding bankruptcy, but generally speaking, an arbitration agreement will be enforced unless there is an inherent conflict with another federal statute. So the question is that inherent conflict going to be the determining factor in bankruptcy cases and the enforcement of arbitration agreements? The case I'm talking about, and that I will write about in the next few days, comes to us from Judge Mashburn, Bankruptcy Judge Mashburn, that is, in Nashville, Tennessee. Here's what happened. 3 creditors got together and filed an involuntary bankruptcy petition against a debtor. As it happened, in the contracts with all 3 of those creditors, there was an otherwise enforceable arbitration agreement. The debtor responded to the involuntary petition by saying, "Whoa, wait, I have a valid arbitration agreement, and I want the arbitrators to decide whether these creditors have valid claims." He said, if there's a dispute of a claim, it's supposed to be arbitrated under the agreement. Well, Judge Mashburn didn't go along with that argument. He found an inherent conflict in this particular case because, as he said, the debtor wanted arbitrators to decide a core issue in terms of whether this debtor should be thrown involuntarily into bankruptcy. And so, as a result, he denied the motion to compel arbitration. However, Judge Mashburn also said something that is important. He said he was not ruling out arbitration forever. He said it would be a different question, and perhaps he might decide differently, if the debtor, after the debtor was in bankruptcy, wanted arbitrators to decide the validity or amount of the claims. As I said, I'm Bill Rochelle, editor-at-large for ABI. I will return same time next week with something interesting from the world of bankruptcy. Until then, be well, stay safe, and perhaps I will be seeing you this coming week at the National Conference of Bankruptcy Judges in Orlando, Florida. Good day.